Yes, ready for dictation. Start. The general manager of the railways and not on any independent consideration of the conduct of railways for non-payment and found that distinction to make all the difference to deny a mandamus for amount admitted to be liable to be paid by the supplies to the Eastern Railways stop. The issue of public law remedy for recovery of money under public contracts has been dealt with in the context of a claim for money for public works affected at great length by the High Court of Guwahati stop. The court found that a writ petition for recovery of amount even if admitted is not maintainable stop passes after the appointed day shall be competent to exercise such functions exercisable under any law in force on that day in those territories may be mentioned in that notification and such law shall have been accordingly stop passes. Although the courts are extremely loath to interfere with the opinion of the experts, there is nothing like exclusion of judicial review of the decision taken on the basis of such opinion stop. What needs to be emphasized is that the opinion of the experts deserves respect and not worship, and the courts and other judicial oblique quasi-judicial forums entrusted with a task of deciding the disputes relating to premature release oblique discharge from the army cannot in each and every siege refuse to examine the record of the medical board for determining whether or not the conclusion reached by it is lengthy sustainable stop passes. In Controller of Defense accounts within bracket pension versus Balchandran within bracket 2005 13 SCC 128 on which reliance has been placed by the tribunal, this court referred to regulations 173 and 423 of the pension regulations and held that the definite opinion formed by the medical board that the disease suffered by the respondent was constitutional and was not attributable to military service was binding, and the High Court was not justified in directing payment of disability pension to the respondent stop. The same view was reiterated in Ministry of Defense versus Damodran within bracket 2009 SCC 140 stop. However, in neither of those cases, this court was called upon to consider a situation where the medical board had entirely relied upon expressed and no effort was made to consider the improvement made in the degree of illness after the treatment stop.